the commencement date and on each anniversary of commencement date thereafter. The commencement date provided for under clause 2.3.1 of the concession agreement was deemed to take effect on the occurrence and continued satisfaction of conditions precedent, such as a written undertaking to the satisfaction of government that all consortium members shall participate in the project by Tibet, received by which the concessionaire of all consents, permits, and licenses that are required to execute the commencement of commence the activities under the concession, among others. The petitioner informed the committee that, subject to clause 15.2 and clause 2.3.1, government provided the concessionaire with the last license and consent being special mining lease on the 1st of April 2016. The first annual concession fee was therefore due on the 1st of April 2017. And therefore, by the time of the notice of default, which was 28th December 2015 and July 2016, that were issued by government, the annual concession fee were not yet due. Therefore, the committee observed that the contradictory date as to the commencement of the concession agreement, subject to the conditions set out in the concession by both government and the petitioner, led to the failure in payment of the concession fees. The committee noted that despite the above, the concessionaire went ahead to pay the following sums: 330 million shillings. These were paid directly to Kilembe Mines Limited to cater for the costs of electricity and power bills by Kilembe Mines Limited to Meme. 2, 250,000 United States dollars towards the annual concession fee. And 3, 1,750,000 United States dollars as annual concession fees that was paid even after the notice of termination of the concession agreement was issued. I will later on elaborate the circumstances of this one. The committee observed that the payment of the above installments demonstrated the concessionaire's readiness to continue with its obligations as enumerated under the concession agreement. Kilembe Mines Limited and the petitioner executed an MOU dated 17th December 2014, marked as Appendix 4, wherein it was agreed that, among others, that Kilembe Mines Limited's outstanding electricity bills shall be taken on and paid directly to Meme by the petitioner, and that the payment shall be offset from the payment of the annual concession fees of the first year to be made to Kilembe Mines Limited. In an email to the representatives of the petitioner dated 18th April 2016, Appendix 5, it was acknowledged that the petitioner had made payment of 120 million shillings to Meme's emergency power line construction, as well as another deposit of United States dollars 250,000 that was made on the 15th of May 2016. The petitioner had made another deposit of 300 million to Meme as shown in Appendix 6. Following the payment of the 250,000 United States dollars, two other installments of 377,500 United States dollars had to be paid in 3 months from 31st May 2016 and not later than 30th November 2016. The committee further confirmed that the same dates for payment of outstanding concession fees were highlighted in a letter of the chairman, CEO of the petitioner dated 14th July 2016 by the permanent secretary to the Treasury. This is marked at Appendix 7. The committee found that the petitioner had made a payment of 1,750,000 United States dollars on the 25th of August 2017. This is marked Appendix 8. This was even after the termination of the concession agreement. The committee was informed by the petitioner's representatives that this payment was made on the understanding that the termination notice would be revoked. The committee noted that the Director Privatization Unit under Ministry of Finance, Planning and Economic Development, Mr. Moses B. Mwase, communicated the account details to which the money should be deposited. This is marked Appendix 9. Honorable Evelyn Anite informed the committee that the said payment was triggered by a notice of termination of the concession, and that in any case, this money was treated as payment of arrears of the annual concession fees. According to Honorable Evelyn Adite, the conduct of the petitioner demonstrated their lack of financial capacity, and she attributed this to the fact that the petitioner was a company that assembles motorcycles as opposed to having expertise and funds necessary to execute this project. The petitioner had not made all the payments towards the concession fees at the time the notice of termination was issued on the 20th June 2017.
Just hold on, Chair. In the public gallery, we have a delegation of students from Joy Domenio Secondary School from Bunya West constituency. They are represented by Honorable Bajire and Honorable Lukia. You're most welcome. Thank you so much for coming. Sorry we delayed to introduce you. And in public gallery, we have a delegation of students from Kampala International University. That is Makinde East, Kampala. They are represented by Honorable Nyeko Derek and Honorable Shamim Malende. Welcome. Thank you so much for coming. Yes.
Speaker, I want to thank the chairperson and his committee that he's giving good presentation. I'm raising a procedure matter. Since they have downloaded this report on our iPads, why can't he just read the recommendations? Then
no, let him read the way he's reading so that we get to understand. Not all of us are good readers, eh? Okay.
I thank you, Right Honorable Speaker. I thank you, Right Honorable Speaker, for your guidance. Madam Speaker, indeed, I agree with you and the House that this being an investigative report, it is important that it is read as the committee prepared it. I thank you. Madam Speaker, according to the petitioner, following engagements with the government officials, including a mediation meeting convened by the National Coordinator, Operation Wealth Creation, General Caleb Akandanaho Salim Saleh, the petitioner made a payment of $1,750,000 United dollars, even after a notice of termination of the agreement, on the premise that was supposed to be premise, that the petitioner will continue to explore the Kilembe mines. The committee observed that the payment of the annual concession fees on the 25th August 2017 was made into the privatization unit's account in Stanbic Bank number 900008173,655. This is marked Appendix 8. This was in contravention of Section 29 of the Public Finance Management Act Cap 171, which provides that all revenue paid to government should be deposited in the consolidated fund unless provided otherwise by Parliament. The committee also observed that issues such as capacity should not arise at the very inception of a project, considering that rigorous international bidding process ought to have been diligently conducted, the basis upon which the petitioner was awarded the concession. Accordingly, the committee established that the petitioner made the payments of the annual concession fees. The committee notes that whereas the petitioner contested the notices of default dated 28th December 2015 and 14th July 2016 in view of the special mining lease issued on the 1st April 2016. There was no dispute in respect of one dated 20th June 2017. The date upon which the last lease was issued had the date upon which the last lease was issued had an impact on the commencement date, which then formed the basis of determining the anniversary and consequently payment of the annual concession fees. The committee findings. The committee examined the various submissions of the stakeholders to ascertain the extent of performance of each of the parties' obligations required by the concession agreement, as required by the concession agreement. Particular attention was paid to grounds upon which the minister terminated the concession agreement. In response to the termination, the petitioner alleged frustration in performing the obligations under the concession agreement due to technical bureaucracies, inadequate coordination without due process of the law in the various ministries, departments, and agencies that the petitioner was required to report to. The petitioner further submitted that Kilembe mines had not been operational for over 30 years, which occasioned numerous challenges to the petitioner during the initial stages. For instance, the infrastructure was dilapidated and required substantial revamping. Kilembe Mines Limited had an existing huge debt of terminal benefits which affected the operations of the concessionaire. The mining and exploration areas of Kilembe Mines were heavily encumbered by squatters, with permanent settlements, developments, and land use activities. As such, the petitioner did not have full access to the entire mines until the encumbrance could be settled. Unfortunately, according to the petitioner, this was not done. Number 4, the occurrence of floods in May 2014 had an effect of disrupting the operations of the petitioner for several months. In response to the petitioner's alleged frustrations, Honorable Evelyn Anite submitted that the delays in handing over Kilembe mines, handing over the mines, were attributed to the need for the petitioner to meet the requirements for transfer in line with Clause 2.11a of the concession agreement. She further pointed out that the concession agreement allowed the petitioner to commence and continue preliminary activities for which consent had been received, especially recruitment. Honorable Evelyn Anide refuted claims of the delayed handover and submitted that Tibet delayed to deploy their own team on the ground and instead hired key personnel relating to the project, Appendix 10 and Appendix 11. She further submitted that the project manager for the petitioner requested through an email that the handover of the be effected on 1st June 2014. That is marked Appendix 12. Honorable Kasai informed the committee that the concession agreement provided for a transition period of a maximum of 8 months to enable 1, transfer of the mining, exploration, and generation licenses from Kilembe to the petitioner. Number 2, to verify the state of assets. Number 3, to clear terminal benefits of workers and to enable the petitioner offer new contracts to workers. And 4, to obtain other licenses such as a clearance from National Environment Management Authority. He further informed the committee that the concession agreement would become effective after Tibet had received delivery and transfer of mineral rights and after payment of the upfront concession fee. This, in essence, affected the commencement date from which time would start to run in respect of performance of key obligations like payment of the annual concession fees. Accordingly, the concession agreement commenced only after the last mineral rights transferred to the petitioner in June 2016. The assertion by Honorable Evelyn Anite that there were delays to start operations were controverted by the fact that the petitioner provided evidence. I kindly request, I'm very close to you, honorable colleagues, so no, it's because of feedback. It distracts the reading. Yeah. I thank you. the assertion by Honorable Evelyn Anite that there were delays to start operations were controverted by the fact that the petitioner provided evidence of appointment of a project manager with a clearly defined job description as well as the required staff. This implied that the recruited staff of the petitioner could not commence work in the absence of other requisite legal clearances, such as the leases and the licenses. Consequently, such delays were bound to occasion unnecessary costs, running costs to the petitioner. Under clause 1.1.62, the mining lease by which the government of Uganda considered the assets in Kilembe mines would expire after 25 years. It is the petitioner's submission that while this was a provision in the concession agreement, the government of Uganda took a unilateral decision to reduce the duration of the lease from 25 to 15 years. The petitioner avers that this decision had the effect of making it difficult for the petitioner to fulfill one of the obligations under the concession agreement, that is to satisfy the government on the commitment of its members of the consortium. Honorable Okasai informed the committee that Kilembe Mines Limited held the leases such as 22151, 4133, and exploration licenses 1212 and 1248, which were considered to the petitioner under this concession agreement. He explained that SML 2151 was granted on the 1st January 1974 and had been renewed over time and was valid when the concession agreement was entered into. He explained that in 2013, when the petitioner came on board, the license was valid until 2016. He stated that it was renewed for 15 years in accordance with the Mining Act 2003 and was therefore valid until 2031. He further refuted the claim by the petitioner that the lease should have run until 2039 and stated that this would be contrary to the law at the time, the law at the time, that is the Mining Act 2003. The committee takes note of the fact that 1.1.62 and 3.1 of the concession agreement added to the effect that the concession period would expire after 25 years. In addition to the dispute regarding the reduced license duration from 25 years to 15 years, which required an undertaking before renewal for the remainder of the 10 years. The committee notes that one of the leases provided to the petitioner was due to expire in 2016, shortly after execution of the concession agreement. This created uncertainty as to the effect of the very short lifespan of the said lease in respect to the concession period. The concession agreement was silent on the treatment of the said lease, which affected the performance in terms of the concession on the part of the petitioner. In respect to the delayed takeover of the mines by the petitioner, pending issues of licenses, no such evidence of granted consent was presented to the committee to substantiate the assertion. Moreover, best international practice requires that rights in form of the crucial leases and licenses exist in order to avoid illegalities and risks that come with unauthorized mining activities. This further created uncertainties among the petitioner and its partners in the consortium. In addition, the financial implication that this would occasion, in addition to the financial implication that this would occasion to the petitioner, the committee observed that the aforementioned bottlenecks had the effect of preventing the petitioner from timely fulfillment of the obligation that formed the basis of the minister's issuance of the termination notice on the 20th June 2017. The committee further observed that although it was the submission of Honorable Okasai and Honorable Evelyn Anite that consent had been given to the petitioner to go on and start the operations, despite the delay to issue them, with the requisite licenses and permits. No such evidence of the consent was availed to the committee. Moreover, such activity, if undertaken by the petitioner, would have legal implications. International best practices require that operations of mines and extractive projects do comply with legal requirements given the high risks involved, which are multifaceted, such as social, economic, environmental in nature. Section 2 of the Mining Act 2003 described the holder as a person to whom a license is granted under the Act, and includes every person to whom that license is lawfully transferred or assigned. The committee further observed that the concession agreement provided for other remedies in the event of default under clause 24.5.3, such as mediation provided for under clause 26, penalties and fines with an interest. In fact, this is the basis on which civil suit number 116 of 2018, Tibet Timber versus Attorney General and Kilembe Mines, was dismissed. The suit challenged the termination of the concession, but was dismissed on the ground that it should first be deferred pending arbitration. What the committee is emphasizing here is that prior to resorting to the aspect of termination, there are other penalties that were in the concession agreement that should have been opted for other than rushing to terminate the concession agreement. It is the view of the committee that government prematurely invoked the option of terminating the concession, yet there were other viable options as elaborated in the aforementioned paragraph. In High Court Miscellaneous Application 2001 of 2020, Vantage Mezzanine Fund 2 Partnership versus Simba Properties Investment Company Limited and another, Honorable Justice Boniface Wamala found that where a contract provides for dispute resolution mechanisms therein, parties must first exhaust those mechanisms before resorting to other mechanisms outside the provisions of the agreement. The court further noted that an arbitration agreement is separate from the contract in which it is embedded. The implications of the above case is that in the event that the contract is rendered invalid, the arbitration agreement remains unaffected, therefore valid. Consequently, anything done under the invalid agreement is subject to the arbitration agreement. Committee findings. The committee found that the termination of the concession agreement was unjust to the extent that the respective government agencies fell short in timely handover of the mines, provision of the requisite legal tools, dealing with the encroachments on the property, settling of huge terminal benefits, among other eminent challenges. And two, that the government did not invoke the dispute resolution mechanism stipulated in the concession agreement. This made the termination of the concession agreement premature. Consequently, the petitioner and its partners were prejudiced in the performance of the key obligations under this concession. Observations. The committee observed that the concession agreement lacked the provision for the appointment of a person who would have been in charge of supervising the implementation of the concession. Honorable colleagues, this observation is premised on the fact that Kilembe Mines Limited, which was ceding the operations, the custody, and the maintenance of the mines, was the one that was appointed as government supervisor of the concessionaire. Needless to say, that out of conflict of interest, Kilembe Mines would have been much more interested in failure of the concessionaire because they needed to take charge. Little wonder later you will learn that they are the ones that took over the concession. The petitioner fulfilled the obligations of payment of upfront concession fees. The petitioner fulfilled it also observed that the petitioner fulfilled the obligation of payment of the annual concession fees, albeit in phases. This conduct was influenced by the existing MOU between the petitioner and Kilembe Mines Limited. The default notice of 28th December 2015 was given prematurely, considering that the annual commencement date that was subject to the condition precedents and that there was no consultation with the Attorney General by Honorable Evelyn Anite before terminating the concession agreement. This is envisaged under Article 119 of the 1995 Constitution. Honorable Evelyn Anite, even when you respond to me from the back, the Attorney General was before the committee and told us you did not consult him, and he was not. He was there.
Honorable, you are addressing the Speaker.
I thank you, Honorable Speaker.
Concentrate on your report.
Honorable Speaker, much obliged. But Honorable Speaker, I would also like to request that the House, particularly your chair, protects me from the constant noise that comes from the Honorable Evelyn Anita just behind the report.
You read the report.
Right, Honorable Speaker. Recommendations.
You are leader of delegation. You come and move this side.
Right, Honorable Speaker. The committee recommends that government should ensure that a high degree of diligence is exercised during the bidding, procurement, negotiating, and drafting of sensitive contracts such as this concession agreement on Kilembe Mines. That the line ministries in the extractive sector should be prudent and seek legal advice from the Attorney General on all legal issues pertaining negotiations, implementation, and termination of agreements. 3, that the Auditor General should conduct a special audit regarding the amounts of money paid out to the various parties and all the bank accounts as stated in this concession agreement. That Honorable Evelyn Anite should take political responsibility for her involvement in the malfeasance regarding the performance and the unfair termination of the concession agreement and consider resigning her position as minister. 7.2, examination of the rights of the parties upon nullification of the concession. The committee held a meeting with the Land Attorney General on the 31st October 2024. The Attorney General provided a written response indicating that the termination of the concession agreement was in accordance with the terms of the concession. He further indicated that the concession agreement was subject in the High Court Civil Suit number 116 of 2018, Tibet Timber Mining Company Limited versus the Attorney General and another before the Commercial Court of the Commercial Division of the High Court, and that it was dismissed on the 18th March 2021 for lack of jurisdiction, and the parties were directed to proceed for arbitration. The Attorney General indicated that there was another case, High Court Civil Suit number 182, 2017, Gilbert Mujoga and Franklin Jocelyn Rukidi, administrators of the estate of the late Sir G.D.K. Rukidi III, versus the Attorney General, Kilembe Mines Limited and Tibet Timber Mining Company, wherein a judgment delivered on the 23rd March 2021, court found that the concession agreement was null and void, and in his opinion, the earlier decision of arbitration was overtaken by the latter decision, which found that the concession agreement was null and void. The Honorable Attorney General acknowledged the mistake on the part of government for the failure to involve one of the shareholders of Kilembe Mines Limited during the negotiation and execution of the concession agreement, which vitiated the concession agreement. During the committee's interaction with the Attorney General, he disclosed that a conflict of interest pertaining the ongoing procurement of another prospective concession. This was based on the fact that one of his former clients is a bidder in the procurement process. The Attorney General, therefore, referred the committee to interact with his deputy for any clarification regarding further information on this matter. Accordingly, the committee interacted with the Deputy Attorney General, and he did not depart from the opinion of the Honorable Attorney General. His response, therefore, was limited to the areas that had not been addressed by the Attorney General. He therefore guided as follows: that the procurement process for the new concessionaire for Kilembe Mines was ongoing, and out of the 7 bidders, Sarai Group had been selected as the best evaluated bidder. That negotiations with the best evaluated bidder were underway with a view of signing a new concession agreement for Kilembe Mines. That government had rectified the issues regarding the shares of the administrators of SAR, GDK Rukidi III, which was the sole ground for the nullification of the concession by court, the agreement between Tibet Hima and government of Uganda by court. That the office of the Attorney General was not responsible for acting on the letter of the Right Honorable Speaker directing the halting of the procurement process of the procurement process of the concessionaire, but the respective line ministries. Honorable colleagues, the assertion of the Attorney General was based on a question by the committee regarding a directive of the Right Honorable Speaker in May, in which she directed the 2 ministries to halt the process of procuring a new concessionaire pending determination of this matter in Parliament. I heard Honorable Joseph Seungu here talk about that particular issue. The committee observed that on the 28th June 2024, the Right Honorable Speaker wrote to the Prime Minister of Finance, Planning and Economic Development, bringing the minister's attention to the fact that a petition was before Parliament, and urged the Minister of Finance, Planning and Economic Development to halt the bidding process of a new concessionaire of Kilembe Mines. The Honorable Attorney General, in his written response to the committee, indicated that the government was in advanced stages of identifying and securing an investment partner to redevelop Kilembe Mines, and he was of the considered opinion that in the interest of good governance, rule of law, and the doctrine of separation of powers, that both the executive and the legislature be allowed the latitude to carry out their respective mandates. Honorable Evelyn Anite informed the committee that the new concessionaire had actually already been identified and that the proceedings of this petition in Parliament were of no consequence. Observation. The committee observed that the High Court Civil Suit number 182 of 2017, Gilbert Mujoga and another versus the Attorney General and Kilembe Mines Limited, held intalia that the plaintiffs, being the administrators of the estate of the late GDK Rukidi, they are now proprietors of the deceased share in the second defendant company. That the first and second defendants wrongfully alienated the plaintiff 380 shares in the second defendant and reallocated them 10 shares. The taking of accounts be made in respect of the second defendant's company's financials, including but not limited to the amount received by the second defendant company in respect of the concession granted to the third defendant and their expenditure. That the first and second defendants acted wrongfully and unlawfully when they concessioned the second defendant's assets comprising Kilembe Mines without the consent and participation of the plaintiffs. The concession of the second defendant's assets comprising of Kilembe Mines to the third defendant be cancelled. The effect of the illegality of the concession agreement between the government of Uganda and the petitioner was decided in McFoy United Africa Company Limited, where a court found that if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for any other order of court to set it aside. it is automatically null and void without more ado. Though it is sometimes convenient to have court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something or nothing and expect to stay there. Observations. The committee observed that.
Chair, first take some water as I introduce my people.
Okay.
In the public gallery this afternoon, we have a delegation of leaders under the Uganda Kingdom and the councillors from Maokota County, Greater Matete, Sembabule District, led Maogola County, Greater Matete, Sembabule District, led by Honorable Katumba Moses and Honorable Biekwaso. Mr. Biekwaso. They are represented by Honorable Namuga Goretti, Seismate, and Honorable Bemugisa. The members are up there. Please stand up. Where are the members?
Right, Honorable. They are being accessed in. Kindly allow them to come in.
Seismate, what do you say? No.
Right, Honorable, allow our people to come in.
Our people. Okay. Let our people be brought. Continue.
I thank you, Right Honorable Speaker. Right Honorable Speaker, the committee observed that whereas the court determined the plaintiff's rights in Kilembe Mines Limited, it is ever appropriate responsibility for the unlawfulness of the said concession agreement. Neither did it determine the petitioner's rights or the cause of action thereafter. It has long been established that illegality can provide a defense to civil claims under the law. As Lady Justice Aracha Amoko, as she was then, stated in the case of Sinba Limited versus four others versus UBC Supreme Court Civil Suit number 3 of 2013, no court will lend its aid to a man who founds his course of action upon an immoral or an illegal act. It is the legal stand that an illegal contract cannot be enforced by any courts of law, as that would amount to court aiding illegality. In the same case above, the Supreme Court unanimously agreed that no court can enforce an illegal contract or allow itself to be made an instrument of enforcing obligations alleged to arise out of a contract or transaction which is illegal once the illegality is duly brought to the attention of court. Basing on the above, once a contract is declared illegal, it cannot be enforced by either court or any organ of government. It is true the impugned concession was declared unlawful and therefore cannot be performed, or no party can enforce its obligation. However, the limits of these doctrines have since been codified in our laws. Section 54(1) of the Contracts Act provides that where an agreement is found to be void, or when a contract becomes void, a person who received any advantage under the agreement or contract is bound to restore it or pay a compensation for it to the person from whom he or she received an advantage. The Supreme Court of the United Kingdom, in the case of Patel versus Mirza, by majority cited two policy reasons as to why illegality exists in defense of civil claims. A person should not profit from their own wrongdoing. Number two, that the law should be coherent rather than self-defeating and should not condone illegality. With these underlying considerations in mind, in determining whether the public interest would be harmed by enforcing a claim, where to do so would be harmful to the legal system. In this case, the Supreme Court declared the contract between the parties illegal, but went ahead and ordered that the plaintiff be refunded a sum of £620,000 advance to the defendant in the performance of the illegal contract. According to paragraph A of the recitals of the concession agreement, the government of Uganda represented that it owns Kilembe Mines Limited, which operates a mechanized copper mine at Kilembe in the Kasese region of Uganda, supported by a hydropower plant known as Mobuku Hydropower Plant. Relying on the above representation, the petitioner entered into the impugned concession with the government of Uganda. However, after termination of the concession, the High Court of Uganda in Gilbert Mujoga and another versus the Attorney General and others declared the concession unlawful for lack of consent by some of the shareholders by Kilembe Mines. The mining business is highly capital intensive and a very risky venture. The petitioner alleges that they had, at the time of the termination of the concession, paid out an aggregate sum of 56,698,648 United States dollars, out of which the sum of $6,690,000 was directly paid to the government. The petitioner further alleged that they had suffered a substantial direct loss totaling to 980 million United States dollars. The illegality can arise by the conduct of one or both of the parties, and whether they knew about the illegality or not. So there is no reason why a perfectly valid contract cannot become illegal due to an illegal purpose developing between the parties midstream after the contract was made. Even then, where there is illegality involved, it does not always mean all the parties are deprived of all the remedies. The common law principles provide that equity shall not suffer a wrong without remedy. In respect to the impugned concession agreement, the petition entered into the said concession believing the same to be illegal. The government concealed that there were other shareholders in Kilembe Mines Limited, which prejudiced the petitioner, who was at that time innocent party to the impugned concession agreement. The rights of the parties to the concession agreement were never determined by court in the Rukidi case, since the single issue handled therein was on shareholding of Kilembe Mines Limited. Alienation of the said shares and the effect of the above on the concession. Remedies.
Madam Speaker, thank you so much. I have listened to the contents of the report being presented by the chair. I've also addressed myself to some of the rulings you've made here. From the contents of the report, there is a mention that the matter actually we're about to consider was adjudicated in court, and court made a recommendation that the parties must go and do arbitration. This matter is coming here for deliberation by Parliament. I wanted you to guide the House based on your previous guidances, which have become part of our rules. Are we not going into res judicata, where this House is going to alter the decisions of the House which were reached before, having set that record clear that any matter the court has resolved must not be tampered with by this House? Please guide us now that this matter has been
Attorney
put
General.
Right Honorable Speaker, I don't know if I missed anything, but I listened attentively to the report as it is being read.
Yes.
And making his reference to the laws and the decisions of court. There is no departure, and so I believe the report is still in line. It is still in order to maintain it as it is.
Exactly.
Yes.
Thank you.
In any case, we've not had the recommendations yet.
Thank you. Thank you. Keep calm. Keep calm. We shall debate the
Madam
report.
Speaker, my issues on first of all are the meeting. This you have allowed this report to be present because all these are precedents we will look to.
The report, the Attorney General has guided, and that's why I called him. He's a legal advisor of government. So I am guiding you that let the chairperson continue and proceed with the report, and we shall consider the report. But meanwhile, as we consider the report, in the public gallery this afternoon, we have a delegation of leaders and the Uganda Kingdom and councillors from Maogola County, Greater. Where is Namuga? Where is Namuga? You know you have a very good member of parliament. You look for Namuga. Namuga, come. These are leaders. These are leaders from Buganda Kingdom and councillors from Maogola County, Greater Matete, Sembabule District. They are led by Mr. Katumba Moses and Mr. Biekwaso. And they are represented in Parliament by Honorable Namuga Gorethi, who is also a vice chairperson of PAC, Central Public Accounts Committee, and they are also represented by Honorable Mary Bemugisa. All these two ladies are very good ladies. Actually, bring them back.
I want to thank you, Right Honorable Speaker, for allowing the people of Zimbabwe to access the Parliament of the Republic of Uganda. I've always been telling them that this is a people's parliament. This is the parliament where the Honorable Minister from the alternative government always sits to represent you. So I want to welcome you. These are the very people who have a road that they've always complained about. That is Kyabakuza Matete Road. And Honorable Katumba Wamala should make a response on that. And two, Right Honorable Speaker, I want to thank you that we were given a seed school. We did not have a seed school in our constituency, but we have one. The only request that we have is the school stopped at senior 4. We want more 1 billion to have senior 5 to senior 6, Right Honorable Speaker. So I want to welcome you to the 11th Parliament. Thank you.
Thank you, Right Honorable Speaker. We want to thank you, our guest, for coming. Thank you for allowing our people in. I'm their woman member of Parliament. God bless you.
Have you heard how they have a very good Senga?
Thank you so much, Right Honorable Speaker. And I want to thank the Honorable Member of Parliament for Maogola County, Honorable Namuga, the constituency where our people are coming from, and are represented by the woman Member of Parliament, and Right Honorable Speaker and colleagues on the side of the government. I'm also the representative as the Minister. I thank you.
Thank you. Where is Ogwang? Please continue. Ogwang is not here.
I thank you, Right Honorable Speaker, honorable colleagues. Remedies available to the parties. In light of the foregoing, there are two possible remedies available to the petitioner. These include 1, restitution, 2, rectifying the illegality and renegotiating a fresh concession. Number 1, 7.3.1, restitution. This is defined in the Black's Law Dictionary, 19th edition, as the return or restoration of some specific thing to its rightful owners or status. From the legal perspective, the parties are put in a position they would have been if they had never entered into the illegal agreement. The petitioner stated that they had paid to the government a sum of $6,690,000 United Dollars in performance of the obligations stated in the impugned agreement. During the committee interaction with the Honorable Minister Evelyn Anite and Honorable Kasai, the issue of the quantum paid to the government was not disputed. The petitioner averred that they spent a total of over 56 million in investment, and in return, the termination led to a loss of over 980 million in investment and projected earnings. As pointed out above, Section 54(1) of the Contracts Act, Cap 284, and in the case of Patel versus Mirza, the government should not unjustifiably enrich itself and benefit from the impugned concession, which was declared unlawful by court. Moreover, the fault that led to the nullification of the concession agreement was at the instance of government. Recommendations. The committee recommends that both the petitioner and government should before a neutral arbiter reconcile the amount paid to the latter in the performance of the impugned concession agreement, as well as the cost of the investment made by the petitioner, with the purpose of ensuring equity in concluding this matter. Number 2, the government should compensate the petitioner all the total sum of investment and costs incurred as a result of this concession. Number 3, upon payment of all the incurred costs and investments, the petitioner should be allowed, for instance, a time of 1 year from the date of payment to uninstall their infrastructure from Kilembe mines. Number 4, the government should not hand over the exploration and operation of Kilembe mines to any other concessionaire prior to full payment of the reconciled amounts or the reconsideration of the claim. 7.3.2, rectifying the illegality and renegotiating the first concession. This remedy is not rooted in law, but it is based on the nature of the business engaged in by the petitioner and the intensity of capital investments and risks involved. Kalejas v. Law number 406, Unconstitutionality and Mining Concession, 2023. In this case, Law 9 of February 26, 1997 of Panama, approving the 7997 contract, was declared unconstitutional on the 21st December 2017 by the plenary resolution of the Supreme Court of Justice. Subsequently, negotiations between the state and the concessionaire led to the formulation of a new concession contract aimed at safeguarding employment, fostering economic growth, and ensuring the state's benefit from the resource exploitation. The new concession contract, executed as a result of negotiation, granted Minera Panama S.A. exclusive rights over specified zones for 20 years, starting from December 22nd, 2021. The committee observed that the concession agreement was declared by court to be unlawful because the government never sought consent of other shareholders in Kilembe Mines Limited prior to entering this concession. The petitioner had taken over possession and had started exploration process in fulfillment of their obligations under the impugned concession. Indeed, they had already started exploration of minerals. The petitioner had already spent huge sums of money and resources in setting up infrastructure in performance of the concession. The petitioner had also spent significant amount of money in paying employees, taxes, debts of Kilembe Mines Limited, and other costs incidental to the concession agreement. However, there was no return to investment recovered by the petitioner, as this concession was prematurely terminated. The government has already benefited from the impugned concession agreement and can still benefit if the illegality is rectified and a fresh concession agreement is negotiated and entered into by the parties. It is more costly to government for the petitioner to decommission and abandon the mines at Kilembe Mines than to renegotiate a fresh concession between the petitioner and government and all other stakeholders in Kilembe Mines. The government has not yet entered into a fresh concession agreement with any other party as of date. It is unfair and unjust since it is fair and just that since the ground for the nullification of the impugned concession agreement can be rectified, the government should seek consent from all stakeholders and enter into a fresh concession agreement with the petitioner. And since the government has not entered into a new concession, it is cheaper to terminate an ongoing procurement process than to compensate a petitioner for the loss of investment and business. Recommendations. The committee recommends that government should consider renegotiating with the petitioner for an award of a fresh concession in respect of Kilembe Mines subject to procurement processes. 7.4. Any other matters incidental to this concession. Honorable colleagues, we are now getting towards the end. Asset stripping and maintenance of Kilembe Mines. During the visit of the committee to Kilembe Mines and interaction with the management of Kilembe Mines, it was established that during the subsistence of the concession agreement, both Kilembe Mines and Tibet had counterclaims of asset stripping. The committee found that the sale of scrap by Kilembe Mines Limited was contested by Tibet until the CEO of Kilembe Mines Limited resorted to issuance of clearance notes for whatever was being taken out of the mines. In the process, various assets left the mines unaccounted for. Further, the committee established that following the termination of the concession agreement, the manner in which the petitioner was evicted was degrading and inhumane. The committee noted that the exercise was characterized by heavy security deployment, harassment, and confiscation of property belonging to the petitioner and their employees. Kilembe Mines Limited admitted to having broken into the petitioner's offices despite their absence. It therefore remains unsubstantiated as to how and who was responsible for the loss of both tangible and intangible property of the petitioner and their employees. During its interactions with both the petitioner and Kilembe Mines Limited, the committee established that 24 computers, documents, electronic data, particularly exploration data, were confiscated. Of particular interest is a report of exploration study that could not be located. The committee further established that there were 7 vehicles that belonged to the petitioner which were never handed over by Kilembe Mines Limited. Instead, 3 of them were said to have been sold, while others are in use by the officials of Kilembe Mines Limited. The committee observed that the takeover of Kilembe Mines by Kilembe Mines Limited after the termination of the concession was tainted by irregularities such as forceful eviction, harassment of the petitioner and their employees, and 2, lack of unorganized takeover after termination of the concession agreement, which caused a risk of loss of important data and property. Recommendations. The committee recommends that the respective government agencies should always ensure appropriate steps are taken while conducting takeover in circumstances such as the scenario between Kilembe Mines and Tibet after termination of the concession agreement. 7.4.2, breach of the corporate governance principles. Good corporate governance principles call for adherence to accountability, ethics, and transparency in the running of organizations and their business operations. Corporate governance principles dictate that companies have robust internal controls and systems so as to detect, prevent corrupt activities. Entities must enforce transparency at all levels and prevent financial mismanagement and abuse of public trust. The government action to unilaterally reduce the concession period from 25 to 15 years without providing an explanation and rationale undermine the concessionaire's trust and confidence in the project. The reduction from 25 to 15 years led to instability in the concessionaire's planning. Further, bureaucratic delays across various ministries contributed to the concessionaire's inability to meet timelines. As a consequence, these governance lapses hindered efficient project execution. The committee found that government and Kilembe Mines were not fair to all shareholders in the company. In this case, the administrator of Sir GDK Rukidi Estate, when they sidelined the shareholder in the decision-making process of conceding the company's assets to the petitioner, which amounted to operation contrary to the 1995 Constitution and the Companies Act. The government and Kilembe Mines were not transparent and honest to the petitioner when they concealed material information as regards to the shareholders in Kilembe Mines Limited, which they adversely affected the rights of the petitioner and resulted into the nullification of the entire concession agreement by the courts of law, hence causing financial loss to both government and the petitioner. There was never a meeting of the board members of Kilembe Mines Limited to initiate the process of divesting the rights and properties of the company, but instead it was government officials from ministries and departments that convened such meetings. Moreover, a board resolution that authorized the process of divestiture was registered after the notice calling for bids had already been published. This was submitted as evidence in the case of Gilbert Mujoga and another versus the Attorney General, and was a violation of the Companies Act. Observations. The committee observes that various government departments did not coordinate adequately, causing bureaucratic delays that frustrated the concessionaire's ability to fulfill the obligation. The government's lack of internal coordination led to the significant bureaucratic hurdles impacting the concessionaire's performance. Recommendations. The committee recommends that future concession agreements should include an explicit clause protecting initial terms from arbitrary changes in order to avoid unilateral changes in the concession terms. 2, government should establish a dedicated committee to oversee multi-departmental projects so as to enhance collaboration and reduce bureaucratic delays. 3, government should take action and discipline public servants that are found culpable in frustrating investors and government projects. 3, government should clearly define the role of Kilembe Mines Limited to avoid conflicts pertaining operations of the divested mines with the concessionaires. Number 5, that the Office of the Inspectorate of Government should investigate individuals who were involved in facilitating the wrongdoings in the concession agreement and take appropriate action. Number 6, the Committee of Public Accounts, statutory authorities and state enterprises should investigate the activities of Kilembe Mines Limited in respect to the operations, management, and custodial responsibility over Kilembe Mines. 7.4.3, absence of neutral party to carry out supervision of the concession. Corporate governance requires that for companies to be accountable and transparent in their operations. This includes disclosing potential conflicts of interest and ensuring stakeholders, including shareholders, customers, and employees, are treated fairly. The committee established that the concession agreement did not provide for a neutral party to supervise and monitor the performance on the concession. The committee observed that the absence of a neutral party created communication challenges between government entities and the petitioner. Consequently, this meant that the ministers were directly dealing with the concessionaire, which communication was not timely and also short of the requisite technical know-how. Recommendation. The committee recommends that the government should, as a matter of policy, appoint a neutral and technical person to oversee and supervise agreements, contracts, and concessions where the government is a party, such as the case of Engineer Dr. Badru Chigundu with the Isimba hydropower project. Presence of freshly harvested timber in Kilembe Mines. During its visit to Kilembe Mines, the committee sought clarification regarding the freshly harvested stockpiles of timber at the site. Kilembe Mines Limited explained that the timber was intended for renovation, operation, and maintenance of the mines. Despite these claims, there was no evidence of any ongoing renovation work at the mines, raising concerns about the actual purpose of the harvested timber. The committee observed that the unexplained presence of freshly harvested timber on site, with insufficient justification for its intended use, suggests possible misappropriation for illegal commercial purposes by Kilembe Mines Limited. The committee recommends that the offices of the Auditor General and the Inspector of Government should carry out a forensic audit of the natural, fixed, and movable assets of Kilembe Mines. Flooding of River Nyamwamba. The committee takes cognizance of the fact that River Nyamwamba, which runs through Kilembe Mines, is prone to flooding. The committee notes that the floods that occurred in May 2014, for instance, had an effect in disrupting the work in the mines, and the petitioner cited the floods as part of the reasons that hampered their operations, causing difficulty in delivering the planned activities. The impact of mining activities at Kilembe Mines poses serious risks such as destabilization and collapse of river banks, which exacerbate the river's susceptibility to damage and contributing to environmental degradation. The committee observed that the fact that the river is susceptible to flooding means, regardless of who the concessionaire is, there is always a likelihood of work being disrupted and livelihood in the area being severely affected. Besides disrupting work in the mines, the floods have caused expansion of the river banks and in turn causing some of the roads that serve the reducing some of the roads that serve the area. Recommendations. The committee recommends that Government of Uganda should establish and enforce comprehensive environmental protection measures tailored to safeguard River Nyamwamba and its surrounding ecosystems, especially given the heightened vulnerability and frequent flooding. Number 2, future concessions should embed stringent and enforceable commitments to sustainable practices that actively mitigate the risks. This may include implementation of advanced ecosystems, control techniques, habitat restoration projects, and continuous monitoring to prevent detrimental impact of the river's structural integrity. 3, establish strict oversight and proactive measures that are essential to protect River Nyamwamba, to prevent further ecological harm and preserve the livelihood of the communities that rely on its health. Alternative mining investment opportunity. Uganda presents various mining opportunities. Uganda has been keen to promote private participation given the favorable geological conditions that present compelling opportunities for both domestic and foreign investors looking into invest in the mining sector. Uganda is also endowed with various minerals, including but not limited to rare earth elements like iron ore, gold, limestone, phosphates, among others. According to the NDP3, there is limited mineral exploitation, development, and value addition due to some of the reasons are there. I got straight to the observation. The committee observed that given the financial and technical potential of Tibet, it is prudent that government takes advantage of their willingness to invest in Uganda, which would contribute to the realization of NDP3. The committee recommends that government should enhance strategies to attract, protect, and incentivize investors across various sectors for socio-economic transformation. Encroachment of Kilembe Mines. During the investigation, the committee was informed that while government had handed over Kilembe Mines to the petitioner, as obliged under the concession, there are various challenges of encroachment on the mining area by squatters and developers. The committee observed that encroachment poses a danger as it impedes operations of the mines. Recommendation. The committee recommends that government should take measures to ensure that the land belonging to Kilembe Mines is protected from encroachers and that encroachers are evicted in accordance with the law. 7.4.8. duration for which Kilembe mines had not been operational prior to concession. The committee noted that Kilembe Mines Limited had not been operational for over 30 years prior to 2013. And this, therefore, posed unique challenges to the concessionaire since the mine required significant capital and technical resources to revamp its operations. Most of the machinery, equipment, and installations had become obsolete and collapsed, which also required time. The committee observed that the necessity of time, heavy capital investment, and specialized technical input should have been considered in evaluating the performance on the concession agreement. The committee recommends that the government takes into consideration such circumstances when entering into concessions of this nature. Commitments to international obligations, international relations, and diplomatic undertakings. The committee recognizes that it is critical for government and its officials to remain sensitive to issues regarding international relations, diplomacy, and multinational cooperation, while advertising, contracting, and executing agreements with foreign investors of such magnitude. The committee observed that the unfair termination of the concession agreement between the government of Uganda and the petitioner could cause unnecessary diplomatic tension between the government of Uganda and the People's Republic of China. The committee recommends that it is essential for government to formally integrate consultations with the embassies of or diplomatic missions of countries from which concessionaires originate as part of the due diligence process. This approach ensures that information provided by prospective bidders is accurate and transparent. It also facilitates a cooperative international framework. This fosters trust and good bilateral relations. Honorable colleagues, the unique nature of concession agreements in the extractive industry. The committee takes cognizance of the unique, risky, and capital-intensive nature of such concession. This dictates that sufficient reasonable timelines should be allocated to the various phases of bidding, procurement, processes, contracting, and actual performance of the concession. Further, it is important for concession agreements in the extractive industries to include aspects of decommissioning, given the huge impact such ventures have in the environment. The committee observed that the concession agreement did not provide for mechanisms of decommissioning. Recommendation. The committee recommends that the government should elaborately provide for decommissioning mechanisms and procedures for all other concession agreements, such as this, to protect the environment and human health. Oh, okay. 7.4.11, the proceedings of the Winding Up Commission. The committee noted that whereas the concession agreement provided that the Winding Up Commission would be set up in the event of its termination, this was done as soon as the notice was issued before the lapse of termination. The committee notes that the appointment of a Winding Up Commission prior to the lapse of the notice of termination created impression of a predetermined conclusion that no amount of interventions would cure the defaults for which the termination notice had been issued. What is worth noting is that the notice of termination was issued on the 20th of June 2017. It took effect on the 5th of July 2017, and it was supposed to last for a total of 60 days. However, within the same month of June, a Winding Up Commission, which should have been appointed after the termination has taken effect, had already been put in place. The hurried appointment of the Winding Up Commission pointed to a rush with which Honorable Evelyn Anite conducted the affairs of this important and strategic project. Recommendation. I said honorable. Okay. The committee recommends that the Honorable Minister for State Finance and Economic Development in charge of investment and privatization is held liable and is cautioned for not following due process resulting into the untold loss to government and the petitioner. 2, government officials that cause similar losses to government should be held personally liable for their actions, inactions, and omissions. Number 3, relevant ministries and agencies should always be prudent and exercise the highest degree of diligence when performing contracts and making decisions on behalf of government. 7.4.12, payment for energy generated for Mubuku 1 hydropower project. In terms of financial commitments, the Uganda Electricity Transmission Company Limited met its obligations to pay Tibet for the energy generated from the Mubuku hydropower station. Payments totaling to 7.9 billion were made to Tibet. This underscored the government's adherence to the financial agreement within the scope of the concession. The committee observed that although the payments provided a steady revenue stream, Tibet's broader operational challenges limited the impact of these funds on their overall project viability. Recommendations. The committee recommends that before granting any concessions and contracts, government should carry out due diligence as a matter of national responsibility. 2, the committee recommends that government must resolve all outstanding claims upfront so that any concessionaire investing in Uganda does so with clarity, confidence, and free from legal entanglements that could jeopardize the progress of the projects. In conclusion, Right Honorable Speaker, honorable colleagues, the committee's comprehensive review and investigation of the petition by Tibet Hima Mining Company Limited has revealed significant procedural coordination and governance lapses before, during, and after the execution of the concession agreement. These systematic failures served to undermine the integrity and validity of the concession agreement. Needless to say, the nullification of the concession agreement was not an isolated failure, but a culmination of factors such as lack of dutifulness and prudence by public officials, conflict of interest, collusion, and insufficient interdepartmental coordination, among others. It is therefore the contention of the committee that strategic government projects such as this should call for deliberate effort to set up technical and administrative mechanisms for their effective initiation, implementation, and performance evaluation. The committee reiterates the importance of supervising performance of agreements relating to the country's natural resources to ensure maximum benefits. Right Honorable Speaker and honorable colleagues, I beg to submit. I thank you for your kind attention.
Thank you so much. You have no minority. There is no minority report.
Right Honorable Speaker, the report was unanimously supported by the committee.
Okay. Thank you so much, Honorable Chair. Honorable members, you've heard the report. I'm happy that we have Minister of Energy here. We have Attorney General. We have Minister of Investment. Now let me start with Anita, Honorable Anita with the E. There's a procedure matter.
Thank you, Right Honorable Speaker. Right Honorable Speaker, the report has mentioned the Office of the Attorney General here on about 2 main occasions. One, that the Office of Attorney General was not consulted when the concession agreement was being cancelled or a notice was being issued. And secondly, regarding the decision of the court on the fact that actually the court ruled that the concession agreement in the first place was actually null and void. So would it be procedure right that we allow the Attorney General to first clarify on those allegations that the office, well, his office was not involved in during the cancellation of this concession agreement, so that it guides the House on how we can proceed as well? Thank you.
AG.
Thank you, Right Honourable Speaker. It is an interesting question because I was not Attorney General at the time, and I think the right person to ask should be the Honourable Minister, whether she consulted the Attorney General. Thank you.
Thank you very much, Right Honourable Speaker. Annette Among, Anita with
the
A. I am very honored to be given the opportunity to come and speak about debate HIMA, the Automobile Limited Company. But perhaps before I say much, I want to welcome the committee from their fruitful trip from China. I could see that it was wonderful, and it is reflected in their minutes.
What's
the order for?
They went. Yes.
I'm welcoming you. Didn't you go?
Thank you, Right Honourable Speaker. Right Honourable Speaker, with the due respect to the Minister, it's in our rules of procedure that a committee has a right to go for benchmarking. When you begin with that, there is a motive you want to impute. So is it in order for the Minister, when he's supposed to begin with the material, to begin with the immaterial, to impute a motive as if there is something that was behind that? Is it in order?
Honourable Minister, the committees have a right to go for benchmarking wherever they want to go. And it is out of benchmarking that they will be able to find out what went wrong and what did not go well. That is that.
Madam Speaker, you're very right. And indeed,
there is another procedure.
Madam Speaker.
Thank you, Madam Speaker. Before the Honourable Minister responds, because it looks like she's going to respond, I would like to understand from the committee, because in most of the reports, they are referring to the Honourable Minister by her name, Honourable Anite and Okasai. I'm standing to be corrected. Were they acting in their personal capacity or as ministers in charge of privatization? If they were acting as ministers, isn't it prudent that the committee amends the report to refer to them as the ministers in charge of privatization, not in their own names? Thank you, Madam Speaker.
Honourable Chair.
Right Honourable Speaker, the committee takes cognizance of the observation of the Honourable Enos, and first and foremost, in the case of probably the Honourable Minister of State for Energy, we probably want to think we will say Parliament is right to request that that is concealed. But in the case of the Honourable Minister for State for Finance, she told us, I took a personal decision. We have it in video because it was recorded in the... I took a personal decision, and I don't mind. If I am going to be sacked over this, let me, as Evelyn Anite, be sacked. It would have been wrong for us not to take her own plea of being quoted as...
Clarification, Chair. Clarification, Chair. Clarification, Chair. Chair, thank you, Madam Speaker. Madam Speaker, I'm seeking clarification from the Chair whether, truly speaking, that the Minister took personal responsibility to an extent of even wishing to be sacked because of her opinion and decision. Because ministers carry political responsibility of the ministry. If that is what she said, that is grave. The fact, if she said that, my sister, whom I know, let me leave that comment because I'll be...
Honourable members, the Minister of State for Investment is Honourable Anite. And it's a very simple thing. Just to say, Honourable Anite, the Minister of State for Investment. Because when you look at Article 117, it says ministers shall individually be accountable to the President for the administration of their ministries and collectively be responsible for the decisions made by cabinet. So it is Honorable Anite, the Minister of Investment. Honorable Kasai, the Minister of State for what? Energy. Okay.
Madam Speaker, I would like to start from the point of my position of welcoming the committee back from China. And indeed, the committee went to China. There were no accidents. They came back. They reported to this house, and I listened that they went to China and they came back. So I am just in order to say welcome back from China, unless they are denying that they didn't go to China.
I did approve the travel for benchmarking.
Thank you, Madam
So it was not anything illegal.
Madam Speaker, I'm not saying it's illegal. In fact, I would therefore want to add you in the list to congratulate you upon sending them to China. They did a good job.
No, you don't have to add me in the list, Madam.
So, Madam Speaker.
Honorable Anite. Yes. Honorable Anite. Honorable Anite. Yes. Yes, Emmanuel.
Madam Speaker, thank you for this opportunity.
Anita, you need to cool down.
Madam Speaker, the Honorable Minister Anite got up at the prompting of the Deputy Attorney General because somebody had asked a question about the role of the Attorney General because of the statements which came from the committee. And the Deputy Attorney General got up and stated that the person who is supposed to answer that question is Anite. And I thought for now, we are not yet looking at any other thing. She is supposed to answer that specific point about whether they consulted the Attorney General or not. So we don't need to go into other things for now. Thank you, Right Honorable Speaker.
Thank you, Honorable Anite. With the E. Answer the question. Don't be hyper. I know me and you, we can be at the worst, but for now, be calm.
Right Honorable Speaker, yes, I did consult the Attorney General at the time. And
okay, that's exactly, that's what. You continue.
Right Honorable Speaker, I do have my evidence. I do have my evidence.
A clarification from the lawyer.
Before he does ask me the clarification, I need to submit further. That I actually consulted the Attorney General, and I will bring the evidence here. And if you allow me to continue with my submission, I will tell you the legal proceedings that I followed.
Honorable Anite, it basically needs a clarification. He has not asked.
I know my honorable colleague is becoming a senior. You are no longer the other youth MP. When somebody seeks clarification, that means I have not understood what you are submitting. My clarification, you are referring to have consulted the Honorable Minister, who is the Attorney General. Attorney General is you seek his legal opinion through writing. Can you lay on table? Can you lay on table the letter you wrote to the Attorney General seeking his opinion on this particular matter?
Thank you.
And his response.
Thank you. This is a house of record. Yes, Timugui. Just a minute. You finish.
Thank you, Madam Speaker. Madam Speaker, the minister has just informed us that he actually sought information, sought clarification. Sorry. sought clarification.
No, it is all correct. It is all correct. Don't mind. You
sought clarification from the Attorney General.
She thought, yes.
Yes, but what I wanted to clarify is that there was an engagement between the Minister of State for Investment and actually the committee. I wanted the chair to come out and inform us whether they actually requested for that written document at that time, and was it actually laid at the time? Because if there was that time of engagement, why is it that it was not laid at that time when they actually had the communication with the committee?
You see, if they did not ask at that time,
that's what.
This is a house of record. This is a house of record where we want evidence-based. Evidence-based.
Madam Speaker, I am happy that that presentation of the committee, or that hearing of the committee, had media. Right Honourable Speaker, there are two issues regarding that matter. One was on whether or not the minister sought the advice of the Attorney General.
No. Alan is
okay.
Panadol is dreaming.
Right.
Can you continue? Continue.
Right,
we are getting out of time.
Right, Honourable Speaker. May I clarify the question of Honourable Otimgiu is to me. The committee asked the minister that question. And the Honourable Minister on that day said all the line ministers are aware. The Minister of Energy and the Attorney General are all aware of the actions she took. The Land Attorney General came on a different date, and we asked the same question. He said, I was not consulted, but in any case, the minister is not obligated to ask me. There are many things that go on in many ministries. Must each of the ministers keep asking me, Attorney General, should I do this? Attorney General. So, she did not have to ask me. She didn't ask me. Number two, there was the issue, because there is the issue of evidence here. There was a second issue where the minister said that the president ordered them to terminate the concession. We asked her, can you give us evidence of the president's directive? She told us, you know how the president works. He calls people in a meeting, we're just in a meeting, and said, I'm tired of these people, terminate. I have members in my committee who can substantiate. I thank you.
There is an
Thank you,
order.
Chair, for giving me way for clarification.
There's an order.
Order. Madam Speaker, is the chairperson of the Committee of Natural Resources in order to put words in my mouth when the proceedings of the committee sitting were recorded. When the committee asked me how I arrived at issuing the termination, I gave them a history, detailed background of the events that unfolded. My first point of reference was a State of Nation address made by the President of the Republic of Uganda, where he made reference, and at the time I was the Minister for Youth, he made reference to the extent that the then ministers responsible for this docket were corrupt and hired, actually concessioned, a quack investor who came here to make motorcycles and gave them this, and he was going to deal with it. And to my surprise, let me finish, I am on order, To my surprise, that happened in 2015. To my surprise, in 2016, my predecessor was relieved of his duty and I was appointed. And when I was appointed, the President of the Republic of Uganda in cabinet again said the concession of Tibet-Hima should be terminated. And following that discussion in cabinet and the directive of the president in cabinet, before I could even take a step as the minister responsible for investment and privatization, this very parliament summoned me in this house and demanded for termination of the concession of Tibet-Hima, the automobile. I then went back, brought reports to this house, to the mismanagement of Kilembe mines by Tibet-Hima, and I gave them my word that I will surely terminate the concession following the legal proceedings. Right Honorable Speaker and dear honorable colleagues, and then I went back, followed the law to the letter, consulted the Attorney General. The concession agreement empowered me not only to terminate the concession by myself unilaterally, but to constitute a winding up commission. And I constituted a winding up commission on the 5th of July 2017, constituted it, and the winding up commission comprised of 6 members, 3 of them from government, 3 from the concessionaire Tibet-Hima automobile. And I laid all this on table. And therefore, is the chairperson of the Natural Resources Committee in order to impute and lie when I was actually serving the country?
I have clarification. Chair, you need to clarify this.
Honorable members,
the chair needs to clarify.
I thought it was an order.
No, I'm not raising a point.
So you want to respond to an order?
No,
I am asking you, are you the speaker?
No.
It was an order. Honorable members, the Minister of Investment and the Minister, and the Chair of Natural Resources, don't drag me into making a decision on where I don't have evidence laid on table. If you're talking, if anybody is saying, I was told to do this, lay evidence on table. If there was a cabinet, lay on table. There was ABC, I want it on table, I will not make a decision. I will not say whether you are in order or whether the other one is not in order because you don't have documentary evidence, and I will not be dragged into that debate. Yes, Council?
Madam
Let me
Speaker,
hear from Council.
I raise on a point of procedure. We have listened to the committee report, very detailed. Isn't it a procedure right that you give the ministers an opportunity to respond?
That's what she's
And then
doing.
we debate. We are itching to debate. We want to debate
You
this
finish,
report.
Anita.
Thank you very much, Madam Speaker and honorable colleagues, for yet giving me this opportunity to respond to the committee report. And before I make statements or remarks on the recommendations of the Committee of Natural Resources, allow me, in brief, just give you a summary, executive summary, of how the Winding Up Commission that I constituted and came up with the conclusion of terminating the concession of Tibet-Hima automobile. This report contains the background to the Kilembe Mines concession and documents that silent issues arising in the report of the concession, the performance or non-performance of the key concession obligations, and the recommendations of the Kilembe Mines Winding Up Commission. The committee was appointed by myself, Honorable Anita Evelyn, the Minister of State for Finance in charge of investment and privatization, and the committee commenced its work on the 5th July 2017. and I did give the House the background to which I arrived at this point of constituting the commission, the Winding Up Commission. The Winding Up Commission was established by the virtue of the express provisions of the concession agreement entered into by and between the government of the Republic of Uganda, Kilembe Mines Limited, and Tibet Hima Mining Coal Limited, the concessionaire. The establishment of the Winding Up Commission was done as a result of government of Uganda having issued a notice of termination of concession agreement referred to above, and which termination notice save for a cure of event, which expire on 5th day of September 2017. Right Honorable Speaker and Honorable colleagues, I gave you a background of how I arrived at this point, because I was prompted by, first of all, the President of the Republic of Uganda in Cabinet and through public address in Serena, Kampala, and this House. Under the terms of the concession agreement, the concessionaire was required within 30 days of the establishment of the Winding Up Commission to present to the Winding Up Commission a summary report on the status of operation as the date of termination notice, and to present a final report 60 days after the establishment of the Winding Up Commission. I emphasize the 60 days. The concession agreement then required the Winding Up Commission to deliberate and recommend to the government of Uganda whether the concession and the concessionaire should seek to transfer the assets and operations to their third party or render for the potential of full cessation of operations and disposition of assets in accordance with the terms of concession agreement. The Winding Up Commission identified 4 key areas in respect of which they required the concessionaire to address them. The concessionaire was required to inform the Winding Up Commission what the status of operations at Kilembe Mines was at the date of termination, the expectations and the deliverables under the concession agreement, and what had been achieved, any challenges faced by the concessionaire, and lastly, the strategies the concessionaire had for fulfillment of the concession obligations. The Winding Up Commission held several detailed meetings over a period spanned close to 4 months while implementing its mandate. So, Madam Speaker and honorable colleagues, I need to pause there a little bit and just inform that the spirit in which the committee reported that we didn't give them time, I didn't do that, I didn't do the other, is wrong, because even then it took 4 months for us, just for the both concessionaire and government, to try to make good of the concession within the winding up period. The concessionaire, upon prompting of the commission, presented a draft report and a summary report on account of the voluminous nature of the information that had been provided during the concession meetings and engagements. The concessionaire never provided a final report, but requested the Winding Up Commission to consider the summary report and the documentation provided as constituted its final report. The Winding Up Commission then deliberated, obtained Chinese translation of its report from the benefits of the concessionaire, and made its recommendations as contained in detail in the body of this report. And Right Honorable Speaker and honorable colleagues, this report actually, I submitted it to the to the Committee of Natural Resources. I expected them to be nationalists and present this to the House, but to my dismay, welcome back from China. The Winding Up Commission, in the course of its duties, engaged with the concessionaire representatives of the government of Uganda, key stakeholders would include, among others, the Uganda Electricity Transmission Company.
Anita, there is an order from...
Thank you, Right Honorable Speaker. I would like to implore you to help us understand the conduct of this minister on this floor and making statements that really demean the committee and members of this House. Is she really in order to continue making such statements in front of all of us? I thank you.
Honorable Minister, as I said, tone down. Have respect for one yourself, for the committee, for members of parliament, and finally for the speaker, if she deserves respect.
Thank you, Right Honourable Speaker. Most obliged. The Winding Up Commission then deliberated and obtained Chinese translation of its report for the benefit of the concession and made its recommendations as contained in the detailed in the body of the report, this report. The Winding Up Commission, in the course of its duties, engaged with the concessionaire representatives of the government of Uganda, key stakeholders who included, among others, the Uganda Electricity Transmission Company Limited, the National Environment Management Authority, the Electricity Regulatory Authority, subcontractors, partners, and agents. In general, the Winding Up Commission established that the concessionaire had carried out some investments at the Kilembe mines, particularly at the mill, in fabricating trolleys and repairing the rail track and the foundry. The concessionaire was, however, unable to provide the Winding Up Commission a physical justify.
There's a procedure matter.
Honorable colleagues, I'm just becoming impatient. The honorable member, Right Honorable Speaker, the chairperson, presented the report. I expected the honorable minister to respond to the report.
Issue by issue.
And I'm only seeing her reading a report. Maybe for avoidance of doubt, if I saw, this is, you keep this. I don't want to read. It's okay. Winding up. The report on the Kilembe Mines Winding Up Commission of October 2017. 2017, a member is has just presented a live report of today. And you are reading for us things that were done in 2017. And for us, you have space to waste all our time when issues are just too many for you to respond to. Is that procedure right, Honorable Speaker, for the Honorable Minister?
Another procedure.
Father,
I'll rule on.
Madam Speaker, basing on the procedure matter submitted by Honorable Tekasimire. But Madam Speaker, really would like you to call. I would like to call my sister to be calm. Let me use that language from Sia border. To be calm. I know, Madam Speaker, always. My brother has a problem with the English language. But my sister, I want you to be calm. And I want you to make our time here very useful. Because truly speaking, the chairman of the committee read the report, and the report had issues. You make much of Busia to look a fool if you begin reading a report of a long time ago, not basing on the submission of the chairperson. The fact I'm one of the people who are confused whether you are doing it whether you are doing the right thing at the right time. I therefore request you, my sister, that why don't you strictly stick to the report of the committee to make us follow well so that we find a solution to this matter. Secondly, Madam Speaker, I request diagram from the minister, because the way you are submitting, you look as if you're on tension, you look as if they are chasing you, you look as if you have fear, you look as if you had conflict of interest, and this lady of NUP supports you. When I talk,
honorable members,
don't talk.
Honorable
Madam
members,
Speaker, this lady should stop intimidating me.
She's on
That is domestic violence to a man like me.
He's
no,
on
stop
procedure.
harassing me.
He's on procedure.
Stop to harass me.
Listen.
Whenever I'm submitting, the lady is harassing me. Excuse me.
Who is attacking?
The honorable member should stop harassing me.
Let me tell you people,
I know.
don't put your personal feelings into this
Sure,
report.
this is a very important matter.
You
really.
get it, eh?
Huh?
We are the same people who are saying we want investors in the country. And if there is a mistake that has been made, we correct it. If it is the investors who have made a mistake, then they should be obliged to correct it. Let's look at all this with the merit. Yes, let me hear from council.
Madam Speaker, I'm raising on a point of procedure once again.
A senior counsel.
And I don't know whether it is right for me to...
Senior counsel.
There is a senior one here. Okay.
Thank you very much, Right Honorable Speaker. The Honorable Stephen Baker had forgotten that I graduated from law school 33 years ago. Right Honorable Speaker, there's a threshold question that ought to be answered before we proceed. And you had started addressing your mind to this fundamental threshold question. The threshold question is, did the Honorable Minister of State for Investment seek and get the opinion of the Attorney General before revoking the concession agreement? That is a constitutional question. Before we consider anything, we ought to see evidence that the Attorney General issued an opinion in writing. Why am I saying that, Right Honorable Speaker? Right Honorable Speaker, wait. Right Honorable Speaker, I have addressed my mind to Article 119(5) of the Constitution. And if you permit me, I will read it verbatim. Subject to the provisions of the Constitution, no agreement, contract, treaty, convention, or document by whatever name called, or document by Right Honorable Speaker, for the benefit of my beloved sister, the Honorable Anite, I was reading verbatim the contents of Article 119(5) of the Constitution. Subject to the provisions of this Constitution, no agreement, contract, treaty, convention, or document by whatever name called, emphasis mine, document by whatever name called, to which the government is a party or in respect of which the government has an interest, shall be concluded without the legal advice of the Attorney General. Shall be concluded without the advice of the Attorney General. Now, Right Honorable Speaker, we are talking about a subsisting contract and the termination of that contract by a document called the termination letter. That could never have happened without the express advice or opinion of the Attorney General. So before we consider any other matter, we need to be convinced by way of evidence that the Honorable Minister procured the opinion of the Attorney General, and she only proceeded in conformity with the opinion of the Attorney General. I beg to submit, Right Honorable.
Thank you. It still goes back to Honorable Anita. Did you, as per the law, consult the Attorney General?
Madam Speaker.
Why don't you listen?
Madam Speaker, the agreement the concession agreement that we're talking about was written by the Attorney General, and the powers for terminating the concession were enshrined in the termination agreement. And I just mentioned that I followed the procedure which is spelled out or laid out in the concession agreement. And Honorable Tinka Kasimire
is drafting the agreement
It's not drafting.
the same as seeking for a legal opinion.
No, if the law is in your hands, the agreement is spelled out. How you enter into the concession and how you terminate the concession. The proceedings are all written down. And I followed the procedures. And Right Honorable Speaker, I will also come back to the House with the report and the names of nominees from the Attorney General to show to you that I actually consulted them and the Attorney General was fully involved in the winding up of Tibet HIMA. And I will bring that to the House.
Thank you, Madam
There's a
Speaker.
procedure matter.
Thank you, Madam Speaker. Madam Speaker, I want to refer you to page 26. The committee says they held a meeting with the Attorney General on the 31st of October, 2024. The Attorney General provided a written response indicating the termination of the concession agreement was in accordance with the terms of the concession. Doesn't that imply that he was in agreement with the process?
Procedure, Madam Speaker.
Yes.
Thank you, Madam Speaker.
Yes.
Madam Speaker, I just want to raise some procedural issue. You had made a valid observation that we need investors, but also we don't need the quack investors. We need investors who can help us and do the right thing, make us to grow. There are situations where you find investors come after exploiting our avenues of benefit, tax benefits. After 10 years, they change names, they change situations. Some say for us, this is not a lucrative venture. We want to close and go. And actually, the same people also come back in different names. Now, when you look at the report being presented by the committee and the issues they have raised, some of them are issues which touch on the minister. And the way I look at the whole things, there are a number of documents which are supposed to be presented as evidence. So my consultation, my view is, we want it to be procedure right, that we give this minister time, reads these documents, and back her submission with the documentary evidence that she has talked about, so that we have a balanced debate based on response, which is also backed by what? By evidence. Because as we look at the whole thing now, if we rush and debate, and yet she says some of these documents are still left behind, I don't think we might be fair in our debate and a balanced debate. So I was just seeking your opinion. Thank you, Madam Speaker.
Thank you. Honorable Anita, you think we should proceed or we give you have evidence? You have evidence that you want to lay on table?
Madam Speaker, I can just bring additional information because my conscience is very clear that what I did was for the good of my country, and I stand with it. I can debate this anytime, any day. And therefore, if you give me the chance to respond to, to the report, recommendation by recommendation, even now, I'm ready.
Go ahead. No, let's get a recommendation. Let's get responses. Let's get responses. No. Let's get responses from the minister.
Right Honorable Speaker, there are three parties that are involved in this. I will only stick to the areas that concern me as the minister responsible, that is issuing notice of termination and then formation of the winding up commission if I did it in accordance with the law. The honorable colleague there my honorable colleague, Honorable Enos, has actually made reference to the committee's admission of the fact that the Attorney General said I did consult, and that therefore rests that particular point. I therefore would like to make reference to point 26 and page 26 and point number 3. Point number 3, having rested the point that whether I consulted or did not consult, I actually did consult, and it has been confirmed in the committee report. And I still want to confirm that I consulted and followed the concession agreement that was written by the Land Attorney General. Now, recommendation number 3 says, Honorable Anita Evelyn should take political responsibility for her involvement in the misfairness regarding the performance and the unfair termination of the concession agreement and consider resigning as a minister. My response to this is that I shall not resign even when I have gained enough capacity to be a private citizen, but I am not going to resign because I did the right thing for the just cause of the country.
Maybe we could make a correction on that, not taking a political responsibility, because it was collective responsibility, not taking a political responsibility. It was a collective responsibility under Article 117.
Thank you, Right Honorable Speaker. Right Honorable Speaker, just to back and justify why I am the most competent minister for that ministry, is that...
That one has been sorted.
Thank you. I just wanted to bring out this point, that Tibet Hima, Right Honorable Speaker, I speak as a citizen, and it really touched me so much and to the level of actually angering me. The fact that Tibet Hima, in the Winding Up Commission, no, it's not to do with this, I'm bringing another point, that our point of departure with Tibet Hima as government of Uganda and is the fact that they wanted 30,000, and they put this in writing, 30,000, and it's here in this report, 30,000 metric tons of copper concentrates, which combine of gold, copper, 30,000 tons. Right Honorable Speaker, you're a businesswoman. You know how much 1 ton only weighs. 1 ton. But these guys, as a competent businesswoman that I know, you will understand what these people were trying to do. Fleece the government of Uganda and the people of Uganda of their natural resources. I actually expected to be given a medal by the committee for saving government of Uganda and the citizens of this country from robbery of 30,000 minerals of the people of Uganda. This is the future of our citizens. I came at a point...
There's a clarification somebody wants.
I came at a point...
Thank you, Right Honourable Speaker. In the same spirit, Madam Minister, now that you require a medal for saving Uganda, the report of the committee said, after rejecting the 30,000 they had requested, you didn't respond whether you were giving them 1 or 10 or 5. So we wanted to know from your office, which kilograms were you ready to give, and why didn't you give them the one you felt could be sufficient for them to do the testing?
Right Honourable Speaker. Right Honourable Speaker, the Minister in charge of Energy and Minerals will tell you under our Mineral or Mining Act how much quantity is required to be taken out of the country as samples. And she would surely come to this house and respond. But the truth is, even because I don't want to do her job, she will respond and tell us the quantities. But to just answer him directly, Right Honourable Speaker, the committee make reference of the meetings and the intervention of General Salim Saleh. All these were meetings that we had in the office. And I held these meetings together with the President in State House, and the rejection and telling them that they cannot take 30,000 tons was done by not myself, but by the President of the Republic of Uganda, President Yoweri Kaguta Museveni, in my presence and in the presence of the investors. So they cannot say we did not give them a feedback of whether they can take the 30,000 metric tons. Right Honourable Speaker, 30,000. Right Honourable Speaker, I've gone through the entire report. There were only 2 issues that concerned me. One is whether I actually acted in accordance with the law, and I thank you for responding to that. The other is that if I didn't act according to the law, I should take a political or whatever responsibility. I have answered it. I am a very proud and happy citizen that I did my job and terminated the concession of Kilembe mines.
Thank you. Honorable.
Thank you, Right Honorable Speaker. I just want to seek clarification from the Minister, because she just stated here that the company, why she cancelled the agreement was because the company was exploiting our resources. I just want to seek clarification from you, Honorable Minister. When you are asking money from these people, $6 million, you didn't know that these people were going to exploit our resources? You first get my money, and then after you cancel the agreement. When I say I want you to refund my money, you give an excuse that we realize that you want to exploit our resources. Why did you take their money when you knew that these people were going to exploit our resources? Or else, after discovering that these people were exploiting our resources, why didn't you refund their money?
Maybe the question would be, what was the 6.6 billion meant for?
Further clarification?
Right, Honourable Speaker. This is one of those debates that are intriguing. There seem to be interesting sides. Here there are those who went to China, there are those who didn't go to China. The minister is telling us she did a job good enough on behalf of the country. The committee is also saying they're working for the good of the country. The lawyer in me is intrigued by something on page 23 of the report. And this is a procedural issue that I'm raising. There's a civil suit number 116 of 2018, Tibet Hima versus Attorney General and Kilembe Mines. So Tibet Hima went to court challenging the termination of its concession. This, and I'm actually quoting the committee report. The petition by Tibet Hima was dismissed by court because they were challenging the termination of their concession, so it was dismissed on grounds that it should first be referred to arbitration. Procedurally, I'm interested. I'm really concerned about the legal matter, yeah? Aside from who saved what and that kind of thing, that all can be conjecture. But the law, which I'm concerned about, there is a court matter. There was a verdict of court. Court dismissed this petition and said go to arbitration. Can we be updated? What happened? How far, if at all, did the arbitration go? Because we might be here, have pettifogging over this and the other and so on. I'm very interested in this legal matter because it might help us with many things. There was a court petition. Tibet went to court challenging its termination, the termination of its concession. Court dismissed their petition and said go for arbitration. So court paved a way that should have been followed. Was that followed? If not, why? Because it will help us and probably avoid even the back and forth that we are having.
Thank you, Right Honourable Speaker. I appreciate the issue raised by the Leader of Opposition. It is true, Tibet Hima went to court, and their suit was dismissed, specifically for the reason that the concession upon which they were basing their suit had a proviso that any dispute relating to the concession should be taken for arbitration first. So they had not taken the matter for arbitration and instead gone to court. And court said, no, you do not have jurisdiction here. Your first instance should be arbitration, as long as the concession is the one on which you are basing your suit. That's the reason as to why it was dismissed.
Thank you. Thank you.
Right Honorable, let me clarify further with the Attorney General. I'm glad he has provided some pointers. Again, my question does not seem to be answered, Right Honorable Speaker. So court is saying you should deal with this the arbitration way. So court provided a remedy, as far as I'm concerned. And I'm interested in establishing whether that remedy was explored. Because also, Right Honorable Speaker, and as one of the colleagues did raise, many times you have dissuaded us from debating matters that either are in court or that have been determined by court. Because if a court determines a matter, Parliament cannot undo it. So the legal guidance I'm giving, and there are many more senior lawyers than myself here, but it's important that we cover ourselves legally. I want to dissuade us, whether it be from, and it doesn't matter who you are for. In fact, for me, I'm for Uganda. That's why I want to know who did wrong and how it gets to be determined. So I'm not going to say I am for Tibet or I am for the decision taken by the minister. All of that, for now, as far as I'm concerned, is conjecture that does not help us. Court provided a remedy and said, go and do arbitration.
Information law.
We need an update.
There's an information
on whether or not arbitration was done. In fact, actually, as you provide that information, Honorable Speaker, when court orders that go and do arbitration, you are meant to give a report back to court. Because court gave its guidance. So how did this matter end? My colleague wanted to give information. Yeah. Senior lawyer.
Thank you very much, Right Honorable Speaker, and thank you, Lord, for yielding the floor. There's no court order to go to arbitration. The suit was dismissed, and dismissed on the grounds that there was an arbitration clause. The parties were bound to go to arbitration in the first place. But the critical information I wanted to give you, Lop, is in respect of matters legal. When you are a subject of arbitration and you elect to go to court, the prevailing position of the law is that you have abandoned your right to go to arbitration.
Thank you for that information. In 30 seconds.
Let me hear from Attorney General.
Allow me just 30 seconds, since he gave me information. I want to appreciate Senior Counsel for the information he has provided. Through you, Right Honorable, I don't know that will be the Attorney General or Senior Counsel who has provided that to guide the House further. So you have abandoned arbitration, which is provided for in the concession agreement. You have gone to court. Court has dismissed your suit. What is your remedy? Because I want to be sure that Parliament is the remedy. Because also, as we are determining this matter, regardless who, court was involved. So if court is saying, I am dismissing your suit, you should have gone for arbitration. Did it happen? Because that's an option that they did not explore at the first instance. What is the latest update, AG?
Yes.
Thank you very much. Perhaps
honorable members, stop just shouting that we are bad. That's why we accommodate petitions.
I'm glad, Right Honourable Speaker, I'm glad Lop has brought it out the way he has. Now, allow me use his position to clarify. I want you to understand, when the report was read, and presented, they talked of suits that were dismissed, okay? But there was also a suit that succeeded. The suit that succeeded is a suit of Gilbert Mujoja, a son of the king of Toro, who was a shareholder in Kilembe, who was not consulted or involved in the negotiation of the concession. He woke up one day only to realize Tibet Hima and government had entered a concession, and yet he was a part owner of the mine who was not consulted. So he challenged that in court. And on the basis of his challenge, court nullified.
That's on page 28.
Yes, court nullified the concession. Meaning that whether they had gone for arbitration, whether Anita had cancelled or not, the concession was a nullity ab initio, in as far as it did not involve the shareholder.
Yes.
So that's what informs the decision of Tibet to go for a petition. Okay?
Yes.
Because there is no concession on which they can base.
Honourable members, listen.
There is no concession on which they can found an action. So the last resort is a petition. That's why they are here. If you are not clear, let me explain again. The government of Uganda, let me start afresh. Right, Honourable Speaker. The government of Uganda advertised for an international bidder to come and run Kilembe. Okay? The presumption is that the government of Uganda has done all due diligence and involved each and every person who is required. And Tibet and others willing put in their bids. Tibet won the bid and signed a concession. Along the way, the concession was cancelled for one reason or another. But whether that concession had been cancelled or not, Mujoja, a shareholder in Kilembe, decided to challenge the legality of the concession itself, because he was a shareholder who was left out, who was not involved. You understand? And on the basis of that, court said this concession was void ab initio. It was wrong from the start. And because it was wrong from the start, government is the one that invited Kilembe and gave them a concession, which later turned out to be non-existent. Remember, they had already paid and committed their finances, resources, time and money. So they choose to come here with a petition. You make a decision as parliament.
As whether they should be given a
compensation.
Compensation,
yes.
Whether they should be returned their money. Just a minute. Yes. The petitioners have come here because you cancelled the concession. And they are saying, you cannot cancel the concession and again take away the money. That is what the petitioners have come to say here. So we have to decide as a country, should we defraud
The court decided already.
the investors? Is that what we are trying to do?
Thank you, Right Honourable Speaker. The AG allowed for me to clarify one simple issue. Right Honourable Speaker, and the reason I have tried to insist on this matter is because we must, all of us, cover ourselves legally. That's very important. Honourable Speaker, severally you have told us that whether it be motions, whether it be reports that we adopt, and you are right, legally, in this House, are only advisory to government. So whenever it is a motion that we pass, if it is a report or whatever the case might be.
A report to the bill.
Come again?
A report to the bill.
To the bill?
Yes.
Yeah, even a report to a bill is advisory. It is a bill once it has been passed, that's a different matter. But all of these reports, petitions, and eventually, when we pass it, for as long as it is not law, it is only advisory to government.
Yes, true.
And for me, I am thinking we must find a legal remedy so that government, even if we eventually pass whatever we pass here, tomorrow they say, well, it was just advisory, they choose to do something else. And that's where, I don't know where the AG has gone, so that I've seen him. So that, that's the clarification I'm seeking for from the AG, to see how he guides government and ourselves for something proper legally. That's a further clarification. This is for lawyers, Honorable Sirwanyi. Senior counsel, the Attorney General, let me finish my clarification to Senior counsel. Calm down. It's okay when I say you're not a lawyer. It's okay. Even me, I'm not a doctor. I'm not an engineer. I'm a lawyer. It's not an offense.
Honorable Solomon, but you did a history.
Yeah, it's okay. Be proud of what you studied, Honorable Sirwanyi. If somebody says, Senyon, you're not a doctor, I'll not take offense. But as I finish up, right, Honorable Speaker, to the Attorney General. Attorney General, please do guide us. What gets to be the ultimate remedy? Because my worry is, whatever we pass here in Parliament will be taken as advisory, and government can choose to follow it or not to follow it. So if somebody was defrauded, as you're saying, right, Honorable Speaker, and then Parliament cannot help them because it will be advisory, how do we cover ourselves as a country so that tomorrow investors don't say,
exactly,
we shall not come, you're defrauding us?
Yes.
Also, how do we make sure an investor does not defraud us? So that's the legal direction that I'm hoping the Attorney General helps us with. Otherwise, we don't want afterwards, it was just advisory, we abandon it and move and do whatever we want to do.
Honorable Attorney General.
It is interesting. It is interesting. Lope thinks because Sirwanyi is a gynecologist, he shouldn't contribute to the debate. Right, Honourable Speaker. Right, Honourable Speaker. Right, Honourable Speaker. Of course, that's a joke. That's a joke, and it's a light moment. And I want to appreciate. Lope once again. You see, the ideal thing to do is to look at the prayers of the petitioner in the petition. What are they praying for? And based on the facts as they have been set before you, you are able to determine what prayers they qualify for and what they do not. You understand? For example, we all agree, or we at least have come to know, that the concession was null and void. So, but they had acted upon it, invested, paid money. Do we simply say, you paid for something that does not exist? So, even your proposal can come in answer to their prayers. That's why I'm saying I do not want to be the one now to make the decision for Parliament.
Yes.
I want Parliament to make a decision, but guided by the prayers.
Thank you. Yes, thank Honorable Akamba, Honorable Baka is back. Then local government and Honorable Pair.
Thank you, Right Honourable Speaker. Right Honourable Speaker and colleagues, in a situation where court dismissed a matter that had been filed by Tibet against the Attorney General on the account of not first exploring the remedy under the concession, it left Tibet with the two options. One, to choose whether actually to go for arbitration, or Tibet had also a right to approach the other party, which is government, and say, government, here is the situation. We entered into a concession that has been determined by court to be null and void, but I've put in money. What should I do? And Tibet chose not to go for arbitration and opted for petition. This parliament is the third arm of government. In a situation where the country is always on the lookout for investors, and this particular investor had come, it didn't have knowledge, to my thinking, that Kirembe Mines had not consulted or had not sought the consent of the other shareholder in Kirembe Mines. It would be far-fetched for us to think that Tibet should just walk away without a remedy. So for me, I think that this parliament is well vested with the authority to look into the petition by Tibet, and then, since our resolution is advisory to government, it will be upon government to look into the resolution of this parliament, whether to renegotiate with Tibet or not. Otherwise, to me, I think that the petition is properly before this parliament. Yes.
Thank you, Council, for your submission. The issue brought by the petitioner here is to seek remedy for government actions. You are aware, before those people came here, they went to court and exercised their right. And court told them that they could not seek remedy in court. The best thing they should have done is to go to arbitration. I'm not sure if they exercised that or not. That matter was, just let me finish. That matter was already determined by court. By asking Parliament to deliberate on this matter, don't you think Parliament will be moving in the direction? Let me raise my clarification.
I'm going to clarify on your issue.
You hear and you allowed me to No. Let me raise the clarification issue, then you've
already sought clarification, and I'm ready to give
You cannot clarify what you have not heard.
I have heard. Let me clarify.
I have not finished.
Let me clarify.
You don't clarify what I have not raised. You don't clarify what I have not raised. You only listen. In this matter, as rightly observed, their interests for this country and their interests for investors, for whatever reasons, those are all good interests. But what we want is a fair deal. Now my clarification is, since those matters were already decided by the court, do you think by allowing Parliament to go and make recommendations
that one was already decided upon? Let's go to the next item. Yes, Honorable Anita.
Thank you, Right Honorable Speaker. Perhaps before we go to the next item, I just wanted to bring it to the attention of the House that whereas Tibet Hima paid part of the concession fee in that concession agreement, which was a nullity, they also benefited from government through sale of electricity, which the UETCL, Uganda Electricity Transmission Company Limited, for power supply for Mubuku 1 hydro project. So even in that nullity, they still were collecting money from government. So I would like to ask the August House that I want to ask the August House that we pass the report with the amendment, because I have no responsibility.
Yes.
That we go and reconcile against the money that they made, and then we come back and report to this House.
Or you pay them, or
whichever,
they
because they also took money from us in this illegality. They also made money.
What the amendment we are making is removing from political responsibility to collective responsibility. Are we together? Are we together? Honorable members, I put a question that the motion for the resolution of Parliament to strengthen accountability mechanism and no, that's the wrong one. Honorable members, I now put a question that the report on the Committee of Environment and Natural Resources on petition by Tibet Hima Mining Company Limited against termination of their concession agreement with the government of Uganda be adopted by this Honorable House with amendment of political responsibility to collective responsibility be adopted by this House. Those in favor say on the contrary, nay. The ayes have it. House adjourned to tomorrow at 2.
Welcome.